Hello everybody, welcome to the series where we are going to be revising today the entire chapter of charges, okay? A pretty much simple chapter. It starts from section number 77 and it goes up till section number 87. Romba easy ana chapter, quick 20-25 minutes la idora revision we'll wind up with complete coverage, okay? In the chapter la main ah நம்ம மூணு விஷயத்தை பத்தி பேசுறோம். முதல்ல வந்து creation of a charge, next is modification of a charge and last is satisfaction. So main ah இந்த chapterல இத பத்தி தான் பேசுவோம். இத தவிர there are some miscellaneous provisions as well, miscellaneous sections as well, like charge must be registered with the registrar, it must be registered by the company, all of those punishment provisions are there. So all of that also along with the revision we will keep covering. First thing that we need to read is what is the definition of a charge. A charge is an interest or a lien which is created on a property or a asset of the company as a security including a mortgage. Ma'am, enna ma'am definition படிச்சிட்டீங்க எங்களுக்கு சொல்லி கொடுங்க. Yes, though it is revision, I will give you a coverage. If you guys remember, in the charge or definition நடத்துறதுக்கு முன்னாடி நம்ம கிளாஸ்ல மூணு words actually discuss பண்ணோம், மூணு terminologies. Pledge na என்ன, hypothecation na என்ன, and mortgage na enna நம்ம discuss பண்ணோம், கரெக்ட்டா? ஆமா மேம் discuss பண்ணோம், கொஞ்சம் ரிவைஸ் பண்றீங்களா? Yes, if you guys remember, pledge and hypothecation was for a movable property and mortgage is for a immovable property, right? That is now ஒரு movable property like ஒரு கோல்டோ இல்ல ஒரு காரோ இல்ல என்னோட ஷேர்ஸோ அதை வச்சு நான் லோன் எடுத்திருக்கேன் அப்படின்னா அது வந்து will come under pledge or hypothecation because those are movable property. இதே என்னோட ஆஃபீஸ் பில்டிங்கோ என்னோட லேண்டோ அந்த மாதிரி ஏதோ வச்சு நான் எடுத்துக்கேன், immovable property வச்சு எடுத்திருக்கேனா then it will be known as a mortgage. மேம் எனக்கு புரிஞ்சிச்சு மேம், pledge and hypothecation movable property க்கும் pledge and hypothecation is for movable property and mortgage is for immovable. ஆனா மேம் movable propertyக்கு ஏன் ரெண்டு டேர்ம் இருக்கு, pledge-உம் இருக்கு hypothecation-உம் இருக்கு அப்படினா the reason is because pledge let the possession gets transferred, in hypothecation the possession does not get transferred. I'm not going in detail. If you guys remember, we took the example of Muthoot Finance where we told when you keep gold and take loan from Muthoot Finance it will be called as a pledge, right? So we read this. So why I taught you those three terminologies is the definition of charge says an interest and interest. What do you mean by interest? That I don't have the possession of that particular asset but I have an interest in the asset. That means நாளைக்கு அவன் எனக்கு loan repay பண்ணலனா இந்த asset வித்து I will recover the loan. So I have an interest in the asset but I still do not have the possession. அதனால தான் in case of hypothecation what do you have? You have a interest. Are you able to recall? And lien is in case of a pledge, right? Because lien means possession. Unpaid seller la படிச்சீங்களே foundation la ma'am அதெல்லாம் ஏன் மேம் கேக்குறீங்க foundation? Yeah, you studied under soga. Unpaid seller la we studied, right? In case of there's an unpaid seller, you have the right to exercise lien against the goods அப்படினா you will have the possession of goods until he makes the payment. So that's what is here also. Charge means an interest or a lien. Interest na நான் இப்போ அந்த கார் என்கிட்ட இல்ல பட் நாளைக்கு அவன் லோனை ரீபே பண்ணலனா அந்த காரை வித்து நான் என்ன பண்ணிப்பேன், என்னோட amount recover பண்ணிப்பேன். So right now I don't have the lien of the particular asset because the asset is hypothecated. However, I have an interest in the asset. That's why it's an interest or lien which is created on the property of a property or asset of the company as a security, and it also includes a mortgage. Mortgage is for what? Mortgage is for immovable property, right? So that is section 2 clause 16. Moving on to the next important concept, difference between a fixed charge and a floating charge. What do you mean by a fixed charge? A fixed charge is created on a specific identifiable asset, whereas a floating charge is created on a class of asset, right? Like debtors is a class, your WIP is a class, your finished goods is a class. So floating charge is created on a class of asset, whereas fixed charge is created on a specific identifiable asset, right? In case of a fixed charge, I can use the asset as well as but in case I want to sell the asset, I need to ask the consent of the charge holder. But in a floating charge, I can use also, I can sell also. There is no need to ask the charge holder. Ma'am, of a floating charge le, let's say this is under floating charge ma'am, இத நீங்க வித்துட்டீங்கன்னா இதுல இருக்க சார்ஜ் என்ன ஆகும், இதுல இருக்க சார்ஜ் வெக்கேட் ஆயிடும். ஏனா floating chargeல அந்த கிளாஸ்ல ஒரு அசெட் வெளில போனா இன்னொரு அசெட் உள்ள வரதான போகுது, அப்ப அந்த உள்ள வர புது அசெட்ல சார்ஜ் கிரியேட் ஆயிடும், அந்த கிளாஸ் விட்டு வெளில போற அசெட்ல இருந்து சார்ஜ் வெக்கேட் ஆயிடும். Are you able to understand? So floating charge is usually created on a current assets and fixed charge is usually created on fixed assets, right? And fixed charge நீங்க யூஸ் பண்ணலாம், பட் அதை நீங்க செல் பண்ணும் அப்படின்னா சார்ஜ் ஹோல்டரோட கன்சென்ட் கேட்கணும். floating charge யூஸும் பண்ணிக்கலாம் செல்லும் பண்ணிக்கலாம் ரைட் அதுக்கப்புறம் நம்ம படிச்ச இம்பார்ட்டன்ட் கான்செப்ட் இஸ் கான்செப்ட் ஆஃப் கிறிஸ்டலைசேஷன் கிறிஸ்டலைசேஷன்னா என்ன கிறிஸ்டலைசேஷன் மீன்ஸ் the point at which my floating charge gets converted into a fixed charge and there are four situations in which crystallization will be triggered. First is in case of winding up, second is in case of insolvency, third is default in repayment and fourth is stoppage in business. In the 4 கேஸ்ல what will trigger crystallization trigger ஆச்சுனா என்ன மேம் ஆகும் floating charge என்னவா கன்வர்ட் பண்ணிடுவோம் fixed charge கன்வர்ட் பண்ணிடுவோம். The reasons explanation and all I have explained in the class. This is a revision so I am going a little quick right. Next is section number 77 which is duty to register. It is the duty of the company to register with the ROC saying that a charge has been created and a loan or a debenture was taken right. Within which time they have to inform this to the ROC? Within 30 days of creation of charge they have to inform the ROC and they can pay normal fees and they will inform through CHG1 or CHG9. CHG1 in case the loan is other than debenture, CHG9 in case the loan is a debenture right. And if they do not do it in the first 30 days then they can do it in the next 30 days by paying additional fees as well as giving ROC sufficient reasons why you could not register it within the first 30 days. So if you can do it in the first 30 days by paying normal fees, next 30 days by paying additional fees. If you did not do in the first 30 or the next 30 you have an extended period of 60 days but here you have to pay a ad valorem fees. What do you mean by an ad valorem fees? Proportionate basis. For example, your loan is 100 crores and they say 1% of the loan is the fee. That means 1 crore rupees you have to pay as a fees right. First 30 நாளுக்குள்ள பண்ணினா normal fees, second 30 நாளுக்குள்ள பண்ணினா additional fees pay பண்ணனும் plus you have to give sufficient reasons why you were delayed. Third, that is extend பண்ணி 60 daysக்கு இன்னும் கொடுக்குறாங்கல அப்போ fees will become ad valorem and there also you have to give sufficient reasons and you must also get a declaration signed by a company secretary or a director saying that belated return did not affect the interest of the creditor. Belated return did not adversely affect the creditor. Is that clear guys? Right? Absolutely clear. Next, moving on. So how much do you get in a total? You get a total of 120 days. 30 plus 30 plus 60, right? First 30 with normal fees, next 30 with additional fees, now last 30 with ad valorem fees, okay? And in case you go for the last 60 days, 30 plus 30 plus 60, in case you go for the last 60 days, also give a declaration which is signed by a company secretary or a director stating that the belated filing did not adversely affect the creditor, right? Moving on to the next point which is consequences of non-registration. The first consequence is you will lose your priority right. You no more remain a secured loan or a secured debenture, you become unsecured in nature. However, you must remember only your priority is lost but however the company has to still repay the loan obligation. The Reliance cannot say that because I did not register the charge I will not repay the loan amount. No Reliance, you have to repay the loan amount. Only thing is that the secured will become now unsecured and any charge against the liquidator will remain null and void right. So these are the consequences of non-registration. Then we studied rule 3, that is the instrument of charge should be verified. In case the property is located in India you should get a handoff of director, company secretary or any authorized officer which is set by the charge holder. In case your property is located outside India it must be the director or company secretary or a person authorized by the charge holder and you must also get the common seal of the company or hand of other person other than the one who is interested in the charge. And once you give your CHG1 or CHG9 the ROC will verify and give you CHG2. CHG2 is certificate of registration and that is a conclusive evidence that you have fulfilled all the requirements that was needed to get your charge registered right. So CHG2 ROC will give you which acts as a conclusive evidence. 1 and 9 number ROC க்கு கொடுப்போம் saying that inga பாரு ROC இந்த அசெட்ல நான் ஒரு சார்ஜ் கிரியேட் பண்ணி லோன் எடுத்திருக்கேன் அப்படினா ROC க்கு இன்ஃபார்ம் பண்றது CHG1 or CHG9 ல ROC உனக்கு வந்து அக்னாலேஜ் பண்ணி ஆமா நீங்க அந்த டீடைல் எங்களுக்கு கொடுத்துட்டீங்க yes the charge has been created னு acknowledgement ROC உனக்கு எதுல கொடுப்பா CHG2 ல கொடுப்பா and that is a conclusive evidence that all the legal requirements of registration has been fulfilled right. and the next is section number 78. இப்போ ஒரு சார்ஜ் ரெஜிஸ்டர் பண்ணல அப்படினா யாருக்கு பெரிய லாஸ்? கம்பெனிக்கு அவ்வளோ பெரிய லாஸ் இல்ல, ஆனா சார்ஜ் ஹோல்டருக்கு அவனோட செக்யூர்ட் லோன் or செக்யூர்ட் டிபென்ச்சர் எதுவா மாறுது? அன்செக்யூர்டா மாறுது. அதனால செக்ஷன் நம்பர் 78 என்ன சொல்றானா, இங்க பாரு சார்ஜ் ஹோல்டர், இங்க பாருங்க ஆக்சிஸ் பேங்க், நீங்க 30 நாளைக்கு வெயிட் பண்ணுங்க. இவன் 30 நாள்ல இந்த ரிலையன்ஸ் கம்பெனி வந்து எங்க கிட்ட சார்ஜ் ரெஜிஸ்டர் பண்ணலனா நீங்களே டைரக்டா என்ன பண்ணுங்க, எங்க கிட்ட வந்து சொல்லிடுங்க. ஏன்னா அவன் ரெஜிஸ்டர் பண்ணலனா அவனுக்கு இதனால ஒண்ணும் இல்ல, ஆனா உங்களோட செக்யூர்ட் டிபென்ச்சர்ஸ் தான் என்னவா மாறுது? அன்செக்யூர்டா மாறுது. உங்களோட செக்யூர்ட் லோன் தான் அன்செக்யூர்ட் லோனா மாறுது. சோ அதனால நீங்க வந்து எங்க கிட்ட என்ன பண்ணுங்க, சொல்லுங்க. ஓகே, within a period of if the 30 days குள்ள அவன் வந்து எங்க கிட்ட சொல்லனா நீங்க வந்து எங்க கிட்ட சொல்லுங்க. The moment the charge holder informs the ROC will send a show cause notice to the company. The company has to show the cause why this charge should not be registered. The application that is made by the charge holder, why it should not be registered. The particular company should show the cause. If the company does not reply within 14 days, then the ROC will go ahead and register the charge, right? So 77 என்ன சொல்லுது, கம்பெனி ஏதாவது சார்ஜ் கிரியேட் பண்ணிருக்கினா நீனே போய் சொல்லிடு. 78 என்ன சொல்லுது, இங்க பாரு சார்ஜ் ஹோல்டர் அவன் 30 நாள்ல வந்து சொல்லனா நீ எங்க கிட்ட வந்து சொல்லிடுன்னு சொல்லுது. அதுக்கப்புறம் செக்ஷன் நம்பர் 81, 85 and 80 ஒன்னா படிக்கணும். 81 எதை பத்தி பேசுது அப்படின்னா, it is an instruction given to the registrar saying that you have to maintain the register of charges. Adani company எவ்வளோ இந்த மாதிரி சார்ஜ் கிரியேட் பண்ணியிருக்காங்க, ரிலையன்ஸ் எவ்வளோ கிரியேட் பண்ணியிருக்காங்க, டாடா எவ்வளோ கிரியேட் பண்ணியிருக்காங்க, கேஸ் அகாடமி எவ்வளோ கிரியேட் பண்ணியிருக்காங்க, இந்த மாதிரி எல்லா கம்பெனியுமே என்னென்ன அசட்க்கு அகேன்ஸ்டாக சார்ஜ் கிரியேட் பண்ணியிருக்காங்கன்னு ROC நீ மெயின்டைன் பண்ண ஒரு ரெஜிஸ்டரை அப்படின்னு செக்ஷன் நம்பர் 81 சொல்லுது. செக்ஷன் நம்பர் 81 இன்னொன்று என்ன சொல்லுதுன்னா, anybody can go and inspect this register by payment of a prescribed fees. And section number 85 என்ன சொல்லுது அப்படின்னா, இங்க பாரு 81ல ROC நம்ம என்ன சொல்றோம், நீ ரெஜிஸ்டரை மெயின்டைன் பண்ணுன்னு சொன்னோம். 85ல நம்ம கம்பெனியை என்ன சொல்றோம், கம்பெனி நீனும் ரெஜிஸ்டரை மெயின்டைன் பண்ணு and இந்த ரெஜிஸ்டரை பர்மனண்டா preserve பண்ணும். It has to be preserved permanently until the dissolution of the company, until the winding up of the company. You have to maintain the register of charges. However, the instrument of charge should be maintained only for a period of 8 years from the date of satisfaction of the charge, right? And in the company maintain பண்ற ரெஜிஸ்டரை இன்ஸ்பெக்ட் பண்ணலாமானா, yes, members and creditors இதை ஃப்ரீயா இன்ஸ்பெக்ட் பண்ணலாம் and others can inspect it on a payment of a certain fees, right? So that is section number 85. So 81 என்ன சொல்லுதுன்னா, ROC நீ மெயின்டைன் பண்ணு, எதை நீ மெயின்டைன் பண்ணு ரெஜிஸ்டரை. செக்ஷன் நம்பர் 85 என்ன சொல்லுதுன்னா, கம்பெனி நீ மெயின்டைன் பண்ணு ரெஜிஸ்டரை. இது ரெண்டுத்தையும் நம்ம ஏன் சொல்றோம்னா, செக்ஷன் நம்பர் 80 தான். ஏன்னா செக்ஷன் நம்பர் 18ல என்ன கொடுத்திருக்காங்கன்னா, the charges with ROC are public documents. எப்படி நீங்க படிச்சீங்க, doctrine of constructive notice ஃபவுண்டேஷன்ல படிச்சீங்க கரெக்ட்டா? Like memorandum of association, articles of association, the moment you publish it with the ROC, it becomes a public document. The outsider should read the memorandum and then enter into a contract with the company. Similarly, registers, once you register the charges with the ROC, it becomes a public document. And it is the responsibility of the outsider to refer to this register before entering into any contract with the company, right? So it is considered to be a constructive notice, and that is section number 80. We also did a big fat illustration for this in the class, right? Moving on to section number 79. So நம்ம இது வரைக்கும் என்னெல்லாம் படிச்சிருக்கோம்? 77 creation of charge by company. 78 company பண்ணலனா charge holder நீ எங்க கிட்ட வந்துரு. 81 ROC ரெஜிஸ்டரை மெயின்டைன் பண்ணு. 85 கம்பெனி நீனும் ரெஜிஸ்டரை மெயின்டைன் பண்ணு. 80 அவுட்சைடர் நீ கம்பெனி கூட கான்ட்ராக்ட் என்டர் பண்றதுக்கு முன்னாடி இந்த ரெஜிஸ்டர் ஆஃப் சார்ஜஸை படிச்சுட்டு தான் போகணும். இட் இஸ் a deemed public document. It is a constructive notice the moment it is published with the ROC. Right? So 5 section முடிஞ்சிச்சு, 11 section தான், 6 more sections. Let's quickly complete it. Next is section number 79. Section 79 என்ன சொல்லுதுன்னா, application of section number 77 in certain cases. Mainly this talks about modification. In case உன்னோட லோனோட டேர்ம் மாறுது, லோனோட இன்ட்ரெஸ்ட் ரேட் மாறுது, ரீபேமெண்ட் ஷெட்யூல் மாறுது, ஏதோ ஒரு மாடிஃபிகேஷன் நடக்குது அப்படின்னா அதை நீ என்ன பண்ணும், ROCக்கு இன்ஃபார்ம் பண்ணும். அதுக்கு நீ எந்த செக்ஷனுக்கு போகணும், செக்ஷன் நம்பர் 77க்கு தான் போகணும். அதனால தான் செக்ஷனோட பேரே பாரு, 79 செக்ஷனோட பேரே application of section 77 77 in certain cases. In case you have a modification in terms and conditions, you will go back to the ROC according to the provisions of section number 77, and ROC will give you a certificate of modification under CHG3, right? And next point is company acquiring a property which is subject to a charge. அப்படினா ரிலையன்ஸ் கிட்ட ஒரு அசெட் இருக்கு, அவனோட ஆஃபீஸ் பில்டிங் இருக்கு மும்பைல, அதை நான் போய் வாங்குறேன். அது வந்து let's say I am DT Limited is going and purchasing it. DT Limited is going in purchasing it, correcta? இப்போ DT Limited அந்த ரிலையன்ஸ் ஓட பில்டிங்கை வாங்குறேன், ஆனா அந்த ரிலையன்ஸ் ஓட பில்டிங் is already subject to a charge. அப்படினா DT Limited company acquiring a property which is ரிலையன்ஸ் ஓட building which is subject to a charge. In case company is acquiring a property which is already subject to a charge, அப்படினா என்ன ஆகும்னா அந்த old charge vacate ஆகி இப்போ new charge will be created. You remember the example I told you, market value is 100 crores, 150 crores, and you are giving it to me for 100 crores. Remember that example that we did, right? The same example. We also wrote the example, if I'm not wrong, right? So we also wrote the example. I hope you will be able to recall that. So what will happen in this case? The old charge will be vacated and a new charge will be created, and that new charge should be created as per the provisions of section number 77. So these are the two cases where you will be redirected to section number 77, and that is section 79, which is application of section 77 in certain cases, right? Application of section 77 in certain cases, and your certificate of modification will be given to you under CHG3, which is a conclusive evidence, right? Next is section number 82, which is satisfaction. Okay, company to report in case of satisfaction. In case your loan is over, you have satisfied your charge, you have to inform about that also to the ROC. Creation appo inform panno, modification appo inform panno, satisfaction aanalo inform panno. Basically ROC is that pakathu veetu auntie who wants to know from what you ate for dinner till with whom you came late yesterday night. She wants to know everything. Similarly ROC also wants to know everything, right? So in case of creation also inform ROC. In case of modification inform ROC. Even in case of satisfaction inform ROC, and the form is CHG4, and CHG4 submit பண்ணதுக்கான duration என்ன 30 days from the date of satisfaction or an extended period of 300 days also you can get and you can submit your particular satisfaction, right? And once you submit your certificate of satisfaction, what the ROC will do, they will not blindly believe you. They will ask this to the bank. They will tell bank, Reliance என்கிட்ட என்ன சொல்றாங்கன்னா அவங்க எல்லா பிரின்சிபலும் பே பண்ணிட்டாங்களா, எல்லா இன்ட்ரெஸ்ட் ரீபேமெண்ட்டும் பண்ணிட்டாங்களா. They are telling that the charge is satisfied. What they are telling, is that correct? அப்படின்னு நம்ம என்ன பண்ணுவோம், first we will ask to the bank. Bank is telling yes அப்படினா then we will record the satisfaction. But bank is telling இல்ல அவன் கடைசி இன்ட்ரெஸ்ட் பே பண்ணல, இல்ல அவன் இன்ஸ்டால்மெண்ட் பே பண்ணல, அந்த மாதிரி பேங்க் ஏதாவது objection raise பண்ணாங்கன்னா அந்த objection ரெக்கார்ட் பண்ணி கம்பெனிக்கு இன்ஃபார்ம் பண்ணிடுவோம் that we cannot record the satisfaction ஏனா we have got this response from the charge holder, right? And the last important point of this particular section is a show cause notice need not be given in case when CHG4 was given to the particular ROC, in that itself the charge holder signed. CHG4 குடுக்கும்போதே நான் யாரோட சிக்னேச்சரும் வாங்கிட்டு வந்துட்டேன், charge holderோட சிக்னேச்சரும் வாங்கிட்டு வந்துட்டேன். In that case you don't have to give a show cause notice ஏனா அவன் தானே சைன் பண்ணியே கொடுத்திருக்கான். ஓகே, CHG4 கொடுக்கும்போது ரிலையன்ஸும் சைன் பண்ணியிருக்கான், HDFCயும் ஆமா இது முடிஞ்சிச்சு சாட்டிஸ்ஃபை ஆயிடுச்சுன்னு சைன் பண்றான். திரும்பி அவனுக்கு எதுக்கு ஷோ காஸ் நோட்டீஸ் அனுப்பணும்? ஸோ தேவையில்லை. ஸோ ஷோ காஸ் நோட்டீஸ் இஸ் நாட் required to be given if while the company has given CHG4 the signature of the charge holder was also present. So basically இதுக்கு வந்து 30 days extended period of 300 days with additional fees, and then there's section number 87 which we'll be reading next. And in case the ROC registers your satisfaction, it will give you back certificate of satisfaction in CHG5, right? In CHG5. And the next is section number 87, which is rectification by CG in the register of charges. So this is like a power manip section. In case you have omitted to give your satisfaction, or you gave some misstatement while creating the charge, you omitted something while creating the charge, ஏதோ ஒன்று தப்பு பண்ணிருக்கேனா கடைசியா ஒன்று மன்னிக்க கூடிய ஒரே ஆள் வந்து ரீஜனல் டைரக்டர் தான். அவங்க கிட்ட you will have to go and apply and plead for condonation, and they will forgive you only if they think that your ground is just and equitable. Only if they think that your ground is just and equitable, they will forgive you, right? And they will forgive you, and they will allow you to file the application in CHG 8. You can file the application to the regional director asking for rectification. So that is section number 87. Moving on to the next, let's quickly finish the penalty section, which is section number 86, which is the punishment section, right? Which says that in case you contravene any provisions of this particular chapter, for the company it is 5 lakhs, and for the officer in default it is 50,000. And if you willfully, knowingly give any false information or incorrect information, then you will be liable for a fine under section 447. 447 is the fraud section. So in that you will be liable for fine as well as imprisonment. So that is section number 86. Moving on to section number 84, which is intimation of appointment of a receiver, manager or a liquidator. In case you have appointed, in case the charge holder or by order of the court you have appointed a manager or a liquidator, you have to inform about the same to the ROC in form number CHG 6, and the ROC will inform this to in back. Okay, you have to inform this to the company as well as the ROC during the time of appointment of the manager, liquidator or receiver, as well as when he is appointed, as well as when he ceases to hold the position. Okay, appointment appo inform pannu in CHG 6, and when he ceases to hold the position also you will have to inform them, right? So that is your section number 84. And moving on to the last section of this particular chapter, which is section number 83, which says that power of the ROC to make entries of satisfaction in the absence of intimation from the company. In case the company has not informed the ROC about the satisfaction of the charge, but ROC has sufficient evidence to his satisfaction that the charge has been satisfied abdina, the ROC can record the same in its register, and it will issue CHG 5 to the company within a period of 30 days of entry in its book of satisfaction. And this particular section is irrespective of, notwithstanding the fact that the company has not informed anything to the ROC, and the ROC itself came to know about it. It has sufficient evidence to prove and to understand that the charge has been satisfied. In that case, it can go ahead and register the satisfaction of charge in the register and issue CHG 5, right? So in the chapter le ivlo sections da irukku. So overall, if we see how this chapter works, is first you start with section number 77 and 78. 77 enna solludhu? 77 solludhu that company you go and register the charge. 78 enna solludhu? Company poleya appo nee enna panna, charge holder nee peidu. Adukapra namba padichadu 81, which is telling the registrar to maintain the register. 85, which is telling the company to maintain the register. 80, where we are telling that these registers are deemed to be a public document and they are a constructive notice, and any outsider should read that before entering into any kind of arrangement or contract with the company. Then we read section number 79, which was about modification. Then we read section number 82, which was about satisfaction. Then we read about section number 86, which was the punishment under chapter number 6. Then we read section number 84, which is appointment of receiver, liquidator or manager. And last section that we read is section number 83, which is ROC to make entries, the power of ROC to make entries, right? So we have covered 77, 78, 79, which is modification, 80, which is deemed notice, 81, which is registrar to keep the record, 82, which is company to report the satisfaction, 83, which is power of ROC to make entries of satisfaction, 84, which is intimation of appointment of receiver, liquidator or manager, 85 is companies should maintain the register of charges, 86 is the punishment section, and 87 is rectification by regional director in case of charges of register, right? So that ends the entire discussion of this chapter. Very, very simple. To sum it up, it talks about only three important things: creation of a charge, which is 77 and 78, modification of a charge, which is section number 79, and satisfaction of a charge, which is section number 82. Along with this, you have to read the punishment section, which is 86. Then you read 81, 85 and 80, and then you read 84, which talks about what? 84 talks about appointment of receiver, manager and liquidator. denominator, right? So that completely ends up the discussion of this chapter. I hope you understood it, and I wish you all the best, and see you in the next video where we will be covering more chapters, right? So thank you so much and have a great day.